Nigeria Can't Try Me by Kanu. The leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has urged the Federal High Court to decline jurisdiction to adjudicate on the charge of treason, a treasonable felony filed against him by the federal government. Kanu, who maintained that he was not guilty to the 7 court charges, stated that from the amended charges, the only elements required to constitute and fund liability for incitement allegedly occurred wholly and entirely in London, United Kingdom, and not anywhere in Nigeria. In this preliminary objection, Kanu urged that the alleged broadcasts were not shown to have occurred at the sea or on the international waters abutting Nigeria, adding that I know as a fact that London, United Kingdom is a sovereign state under international municipal law and has municipal laws punishing criminal offense. The preliminary objection filed by counsel to Kanu, Barrister Ifeanyi Ejiofor, further stated that I also know as a fact that jurisdiction is extrinsic to adjudication. It is conferred in a court and it is not intrinsic. That I know as a matter of fact that as the elements necessary to constitute incitement in the alleged several broadcasts of the defendant applicants occurred in London, United Kingdom, and not in Nigeria. The court in Nigeria has no jurisdiction to try the defendant application on any charge founded on any such allegation, incitement, even if the defendant applicants enter within the geographical boundaries of Nigeria. The affidavit in support of the objection deposed to by Chiwe Omiche averred that the alleged offense for which the defendant was charged do not constitute terrorism offense in London, United Kingdom, where they were allegedly committed. I am further aware that there is an allegation on the Attorney General of the Federation to maintain international cooperation for compliance with international treaties on terrorism. The defendant was abducted from Kenya and consequently extraordinarily rendered to Nigeria without firstly subjecting him to extradition proceedings in Kenya. This is a violation of all known international conventions and treaties on extradition. Prosecuting the defendant on the 7-count charges would amount to allowing the complainant to benefit from their illegality and wrongdoing. I am aware that he who comes to equity must come with clean hands, and no party should be allowed to benefit from his wrongdoing. I know as a matter of fact that the extraordinary rendition of the defendant robs the Honorable Court of the requisite jurisdiction of trying the defendant on counts 4, 5, 6, and 7 of the charge. Counts 1 and 3 of the charge were brought under a non-existent law. Count 3 of the charge relates to an offense allegedly committed in Abu Liwiziuzo in Ihiola local government area of Anambra State, which is outside the territorial jurisdiction of the court. An offense can only be tried by a court exercising jurisdiction over the place or area where the alleged offense was committed. Count 5 and 6 and 7 of the charge did not disclose an offense known to the law. There is no proof of evidence attached to the charge filed against the defendant. Even the purported proof of evidence to be relied upon by the prosecution does not disclose any prima facie case against the defendants. From the list of exhibits and witnesses attached to the charge, there is nothing related to or linking defendants to the 7-count charge, particularly counts 4, 5, 6, and 7 thereof. No final pronouncement has been made on the purported proscription of the indigenous people of Biafra, as the said purported proscription is a subject matter of appeal in appeal number CAA 214/2018, pending before the Abuja Division of the Court of Appeal. The defendant's application cannot be arranged anew or tried for an offense when the judgment that made a pronouncement on the instrument constituting a state of affairs as such an offense as the subject matters of an appeal. It will be most unjust, painful, wicked, and unfair for the applicant to undergo the rigors of a full trial when the charge as constituted does not disclose a prima facie case against him. There is no ground for his court to proceed with the trial against the applicant in the circumstance of this case. The court has the power and a duty to stop a prosecution which on the fact creates abuse and injustice. It will be the best interest of justice if the present 7-count charges is struck out and or dismissed. Kanu in detention asks the following question for determination whether the court has the requisite jurisdiction to try the defendant on the 7-count charges in view of the extraordinary rendition of the said defendant applicants. Whether the court has the jurisdiction to try the defendant applicants for allegedly acts constituted wholly by elements that occurred within the geographical space of a foreign sovereign nation and outside the jurisdiction of the court. Whether the defendant applicant can be prosecuted for allegedly belonging to a proscribed organization when the purported proscription of the organization is the subject of appeal in the appeal number CA A21418 pending at the Court of Appeal Abuja Division. Whether the information as laid under counts 1, 2, and 3 of the amended charges is not founded under a non-existent law. Whether the radio broadcast allegedly made by the defendant applicant constitute an offense of reasonable felony as envisaged under Section 41C of the Criminal Code Act CAP C38 Laws of the Federal Government of Nigeria 2004, whether the information contained in counts 5 and 6, 7 of the charges disclose the commission of any offense known to law, whether the proof of evidence in support of the 7-count charges disclose a prima facie case against the defendant applicants. Kanu thereby urge that this extraordinary extradition from Kenya to Nigeria robs the court of the requisite jurisdiction to try him. Oh goodness, this is getting more and more interesting. Wow, if you ask me, Kanu's lawyer has already finished all of them all. Well, let them continue fooling themselves. They think that they are going to get away with these things they are doing. No way, no way. Just imagine it. For the fact that they kidnapped Nnamdi Kanu to Nigeria alone, that one is already a goner for them. Well, you can go to the comment section and share your take on this article. Thanks for listening.